My name is Wojciech Kornacki, and I'm a government contracts and compliance attorney at Central Law and Consulting. Our law firm is a women-owned small business, and we assist federal contractors in all aspects of federal procurement law and compliance. This presentation is for educational use only. If you have any questions during this presentation, please write them down, and we will have a general question and answer session at the end. Please ask only general questions. If you have any specific legal questions, it is best to schedule a confidential consultation with an experienced attorney to address them specifically. Now, this is our agenda for today. First, we will talk about the regulations, the International Traffic in Arms Regulation, the Export Administration Regulation, and Office of Foreign Asset Control regulations. Then we'll talk about the export enforcement and new cybersecurity trends. Next, we will talk about the export control reform and new business opportunities that are provided by the Small Business Administration and the Bureau of Industry and Security. Finally, we'll talk about cost-effective compliance. Probably out of all the different types of federal regulations, export controls are probably some of the most dangerous regulations out there. And this is because there's multiple very serious criminal penalties associated with violating the export control regulations. There's also multi-million-dollar liabilities, and all the issues or all the violations seem to always deal with some national security issue or violations. However, U.S. exports can also be very profitable for those companies that can get their export control compliance in order and seize on the new post-export control reform opportunities. And because there's a lot of opportunities out there. So now let's first talk about all the regulations. Essentially, the basic policy behind the export controls has been since the beginning that U.S. taxpayers spent trillions of dollars on developing new weapons and new technologies to give the United States scientific and technological advantages over their adversaries around the world. And these new technologies and new weapons and new delivery systems must be protected. And this worked very well until the end of the Cold War, because after the Cold War, there was a massive shift in the development of new technologies, the Internet, massive advances in tracking and monitoring and software and computers. And essentially, this basic policy became outdated. The U.S. government also has other policies to control export controls. This includes identifying future threats and also promoting regional stability. And probably you remember that back in 1990s, where there was a civil war in Yugoslavia or in the former Republic of Yugoslavia, there was a massive export control ban on any weapons or defense articles sent there, and this was to promote regional stability. Currently, the United States has a lot of other policies around the world where there's embargoes on North Korea, Iran, or other countries. And it's very important to identify this as a compliance issue before proceeding with the transaction. However, since 2009, there has been a new policy that has been evolving, and the export control reform is one of the signs of this new policy. This new policy recognizes that in order for U.S. businesses to stay competitive in the international market, they must be able to sell a lot of items which are available on international markets. So if there's some export control law domestically that prevents U.S. businesses from selling it, but this product or this technology is available around the world, maybe the law needs to be changed. And this is the underlying motivation for the current export control reforms, to allow small businesses to sell more, to export more, and to create loans and grants and other opportunities. And that's what we'll be discussing today. On this slide, you can see the historical background of the U.S. export controls. essentially, Japan attacked Pearl Harbor as part of the United States deciding to place export controls on scrap metal, which didn't allow Japan to use it to build more warships. This was right when Congress passed the Export Control Act of 1940. During the Cold War, the United States was very concerned with protecting its technologies, weapons, and research, and it criminalized a lot of aspects of export controls. And those criminal penalties exist today and have expanded, and that's what makes it a very dangerous area of federal regulations. After 9/11, there has been a massive shift and massive advancement in various technologies, the internet tracking and monitoring capabilities of different countries, drones, and otherwise. And a lot of those ITAR and ITAR regulations have from 1950s, 1960s, 1970s, and 1980s just became outdated. But there hasn't been really a serious push to update them until 2009. So U.S. businesses found themselves in a situation where they couldn't sell products that were widely available internationally that were made in the United States because there was an export control prohibition under the ITAR or otherwise. And this prevented U.S. businesses from competing internationally. So this new policy and this new reform started to take shape, especially in light of massive trade deficits. The Obama administration decided to go item by item through all the different defense articles and defense technologies that have been considered classified and protected, and see what really needed to be protected. Some of the technologies today in our smartphones used to be on the United States munitions list because of they could be used for military purpose. But this has been changing. So essentially the underlying framework of the export control regulation and reforms has been to reduce compliance requirements, reduce fee requirements, and streamline the entire process, which has already proven beneficial to the U.S. government and to a lot of U.S. Exporters as well, and we will see this in the presentation. So let's start talking about the Arms Export Control Act. Essentially, this law says that selling or exporting internationally is a privilege. It's not a right under the United States law, and based on that, it's the president who decides who gets the privilege of exporting internationally or not. And any exporter has to comply with the international trafficking arms regulations in order to be able to enjoy this privilege. And the international trafficking arms regulations essentially has the United States munitions list, which has 21 different categories, and this list covers all the controlled items and services for which any U.S. exporter needs a license. If they don't have the right permit, or if they sell the wrong number of items to the wrong person, that's a violation and it could have very serious consequences. This United States munitions list is also concerned with dual-use items, and this is essentially when an item can have both a military and civilian technology. A lot of items we don't commonly think can have both, so it's very important to always go through the list. Now, the export control reform has recognized that a lot of these items and definitions have been outdated just because of the new technologies and new advancements in different areas of science. So in the last 7 years, the U.S. government has been going through each item and essentially updating it, removing it, and moving it to another list, which is the Commerce Control List, which has a lot less requirements for compliance. The export control reform also redefines key terms such as what is an export And effective September 1, 2016, there will be a new rule, a new definition setting out what is an export. This definition is essentially designed to synchronize the ITAR definitions with other U.S. laws, because Department of Commerce has their Commerce Control List, and there's been new defense agreements with the United Kingdom and Australia, and a lot of those definitions by different agencies just have been out of date, and they have been not compatible in some ways with one with the other. Now, I started to talk about the Department of Commerce. So essentially, the Department of Commerce regulates many items, not all items, but a lot of items, including the ones that have been recently moved as part of this export control reform from the United States munitions list. The applicable law here is the Export Administration Regulation. Now, there's a different set of regulations and requirements. It's lower, and there's less requirements, and there's less fees. So that's a benefit for a lot of U.S. exporters and small businesses, because once they can identify some of the potential buyers for some of the products that have been moved, they will have lower fees and less of an administrative burden in terms of selling this and going through the transaction. Now the Export Administration Regulation has different reporting requirements as well, but they're much smaller than what the Department of State required through the ITAR. The key takeaway from the Export Administration Regulation is that not all goods and services are subject to the Export Administration Regulation or the ITAR. But it's important to know which ones are not, because a lot of businesses don't do the proper checking, and all of a sudden they get a letter from the Bureau of Industry and Security saying that they've been selling something which is on their list and they didn't properly report it. Now, the end result and the end goal of the export control reform is that if a foreign business seeks to procure certain items that have been recently removed from the United States munitions list, now the U.S. business can sell them without any fees and can do it quicker, which makes them more competitive. The goal of the Department of Commerce is to stop the spread of weapons, which they do by monitoring and by having the commerce control list if there's any dual-use items, but also to maintain the health of the U.S. economy. And they have taken a lot of steps in terms of to be more user-friendly for small businesses, more approachable, and they also provide advice to a lot of small businesses, which is available. Now, another important aspect of export control is the Office of Foreign Asset Control. Essentially, this is another economic and trade control tool that the United States government uses that requires your attention. It may be perfectly legal to sell an item to a foreign business, but then the Office of Foreign Asset Control prohibits transactions with a particular entity or with a particular individual. You probably heard about North Korea or Crimea not being able to process any financial transactions by MasterCard or Visa. That's part of the U.S. economic and trade controls to enforce its diplomatic policies. From the compliance perspective, if someone offers to buy everything that you're selling in cash, you may want to check if they're blacklisted in the OFAC blacklist, because this could be one of the potential red flags. But essentially, that's another way to avoid any issues just by doing due diligence when it comes to the Office of Foreign Asset Control and their prohibitions. Now, this is probably one of the most important slides during today's presentation when it comes to compliance, because it shows you some of the key players in the export control regime. So first we have the Department of State, the United States Munitions List, and the International Trafficking Arms Regulation. Then we have the Department of Commerce, Export Administration Regulation, and the Commerce Control List. Series 600, that's where all the items from the United States Munitions List are transferred to the Department of Commerce. And they're assigned number 600. There's a lot of other agencies that are currently involved in the whole export control regime. So you can see DoD on top of it. Department of Defense is very heavily involved because a lot of items and a lot of defense articles and technologies are what the Department of Defense needs to know. Department of Homeland Security, other agencies, there's international embargoes and sanctions and excluded parties. So in order to have a good compliance that allows you to focus on making more profits, it's important to consider all these different aspects. In the future, the goal of the export control reform is to just have one agency responsible for everything. But right now, the export control reform is not there yet. Now let's talk about some of the key terms when it comes to the export control mechanism. So essentially, these are the terms that any exporter needs to know when it comes to the international traffic in arms. So what's an export? Today, with the new technology, an export can be a simple email to an individual in a foreign country, or it can be a phone call if someone is calling and saying, hey, can you tell me how to assemble M16, or can you tell me how to assemble something else? Or it can be a visit from a foreign dignitary to your facility. They look at some technical data on your computer screen, and then this could be an export. And without proper compliance, without proper permits, that's not allowed. So it can result in a lot of compliance issues. Now, a license is essentially a document that allows any U.S. exporter to sell a specific amount of items at a specific time to a specific individual. So if a license says you can sell 5 and you sell 6, that's a violation. Now, what's a defense article or a defense service? Essentially, the definition is quite extensive, but it's any item or data on the United States Munitions List, unless it's just used purely for marketing. And usually it's best to have your compliance officer or someone else do a quick review to make sure that some of the other data is not revealed at the same time. Service, defense service, is any military training, military assistance, technical assistance, or educational assistance. Recently, Blackwater got in trouble, or any other company that essentially provided training in a foreign country that was related to the military or to tactics. They didn't have a proper permit, and then they had to resolve this through an agreement with the Department of State and pay penalties and otherwise. So service can be almost anything relating to training and military, or even participating in an exercise. Technical data has a very broad definition as well, but it's essentially any information for design, development, assembly, or of a defense article. It can be a drawing, blueprint, or otherwise. So if there's some drawing or blueprint hanging in a conference room, and there's a foreign dignitary coming in, that could be an issue, because they could see this, and that could be considered an export. Software is essentially any software designed for testing, operating, repairing, or otherwise. A lot of contractors have software on their thumb drive. They travel to a foreign country. They can be screened at the airport, and now this could be considered potential export. Public domain is one of the exceptions to the export controls. Essentially, it states that so long as some information is published in an article or in a book, then it's considered to be within public domain. Now, just to show how outdated the rules are, currently the rules are being finalized to address the development of the Internet, because you can post a lot of information on the Internet, and some of this could also constitute an export. One example of this was when an individual published a design of a 3D printer gun that could be made, and within several days there was over 100,000 individual downloads of the instructions, and the U.S. government had to move very quickly to shut it down because this was creating a lot of risks. Now, U.S. person and a foreign person are also two common definitions or parts of the regulation that come into play. Essentially, a U.S. person is any company or a person that is legally in the United States. However, they have to be there permanently. So if there's a foreign person who's just visiting, or if they call you on the phone in another country, or they're just visiting and you're seeing them overseas, then they could be considered a foreign person, and you're not allowed to disclose any information without going through the proper channels within the United States government. Commodity jurisdiction is one of the ways where a contractor or a business can ensure compliance. Essentially, this requests an administrative determination from the Department of State in case there's any doubt. So, for example, you want to sell a certain article or several hundred of those articles to a foreign country or to a foreign business. That you did due diligence to make sure that they're good to sell, they're not excluded, but you're just not sure if this item is on the United States munitions list or not, because it's not listed there. So you can use commodity jurisdiction to determine this, and that's probably where a compliance officer or an attorney can be of most assistance. Right now, because of the export control reform, a lot of commodity jurisdiction requests are actually to double check that the item you're selling is not on the list. Before the export control, everyone wanted to make sure that the item was on the list to obtain the proper permit. Now everyone wants to make sure that the item is not on the list, so you don't even have to go through the permit. The empowered official in the regulation is the individual that has an independent authority to process all the documents for proper export control and compliance. This individual has to have an independent judgment. If they're not comfortable signing some form requesting permission because they think dates are not accurate or otherwise, then they can say no, we're not proceeding with this. So essentially, under the ITAR, the U.S. government has shifted the compliance requirement on individual businesses. And finally, violations can be very serious. They're listed in multiple parts of the ITAR, and I have one slide just listing all of them. Now, when you see 120.17 or 127.2, this goes to 22 CFR 120.17, because essentially this is Code of Federal Regulations that is applicable to all the U.S. exporters. Now, we will address some of the export enforcement that the United States government has been using as part of its reform as well, because while a lot of items are taken off from the United States munitions list, the United States government is also enhancing its export control on the few items that they still control. And this is the slide with all the different criminal statutes that you can see that are applicable and that make non-compliance so dangerous. Essentially, there's a lot of laws that Congress passed that deal with spying, violating national security, or supporting terrorism. But so long as you're compliant with these regulations, sales to foreign governments or to other businesses can be very profitable. So it's very important to ensure that you have efficient compliance to avoid some of the pitfalls. Now, a lot of non-compliance is dictated by individuals who are just not interested in compliance. They're more focused on how to get the technology, sell it to a foreign country, or they're just acting on behalf of the foreign country. So the United States government publishes a list of the major incidents where there's non-compliance. There's already been one this year for $4 million for a business that didn't do proper due diligence, and they were selling a lot of items to a distributor right next to Iran in United Emirates, and then this distributor there was just shipping them across the border to Iran. But as you can see, some of the red flags from the compliance perspective is if someone wants to sell something to Russia, Iran, China, or any neighboring country, maybe that's something to look into because that could be an issue. Also, a lot of foreign businesses or individuals are trying to get some of the items, and you can see which items are in high demand: night vision goggles, night vision scopes, microelectronics, or just designs, because if a U.S. government or if the U.S. government or a U.S. business spends millions of dollars on developing the new product and someone can just get the blueprint, then they just save themselves a lot of time and money. So if someone offers you a lot of money in cash to send high-powered rifle scopes to United Arab Emirates, perhaps that's a red flag, especially if they're not asking for any other services that you would normally have with the same transaction. Now, in September of 2015, the United States Department of Justice published what is commonly known as the Yates Memorandum, and this is essentially a memorandum that shifts the focus from corporations to individuals. So essentially, the U.S. government doesn't want to only go after corporations and ask them to pay millions of dollars in penalties. Now they also want to go after CEOs with criminal punishments or convictions. And this is because previously the United States government has been obtaining inconsistent results. In some of the violations, the company paid several $100,000 and they moved on. In others, which were comparable, the company had their CEO plead guilty to violating the ITAR regulation or otherwise. So now they want to synchronize this. They will go after the company. They will go after individuals. From the compliance perspective, it is always good to have one of the senior corporate officers involved in monitoring and correcting any issues, because if you have a proactive compliance from the top, you can spot it quickly. You will not have an issue as on the previous slide where someone is selling hundreds of items to a foreign government before some non-compliance is discovered. And also this brings the senior corporate officer to the attention of the compliance office, and also it tells the U.S. government that this company is serious about compliance because they assign one of their key individuals in the company. Now, a lot of you probably heard about the False Claims Act and key time lawsuits. Essentially, if a federal contractor submits an invoice to the U.S. government that is not correct, intentionally or is otherwise defrauding the U.S. government, that could be a key time lawsuit under a False Claims Act. But this law has never been actually updated for inflation. So last year, the U.S. government has had another law, Federal Civil Penalties Inflation Adjustment Act Improvements Act of 2015, which essentially requires all agencies to update their regulations on penalties. And as you can see here, for violating the Arms Export Control Act, different sections, the penalty was $500,000. But as of August 1, 2016, it goes up to over $1 million in one instance, and then close to $1 million in two others. So from the perspective of compliance, if there's any violation before August 1, it's best to report it before August 1 because then the individual or the company could be subject to lower penalties. Now, the U.S. government still retains its discretion, so not every violation amounts to $500,000 in penalties, but it's definitely a greater leverage than now. After August 1, it's over $1 million, or it's close to $1 million. The other aspect of this is if there's a violation that occurs before August 1st, but it's reported after August 1st, then new penalties apply. So in terms of cost-effective compliance, it's probably better to report it as soon as it happens, because that's not only required by law, but also because the penalties will be greater after August 1st. Now, how the U.S. government enforces compliance based on the new export control reform. Part of this is the partners that you deal with. So after you do due diligence, sometimes the U.S. government wants to check this foreign business that you're dealing with. So the Department of State has a Blue Lantern screening program where essentially they will go to the foreign business and check whether they're compliant, because the ITAR also places certain requirements on a foreign business. Last year, there's been over 63,000 individual permits issued for different transactions involving defense articles and defense services. The Blue Lantern check has been done only on 564, and 20% of those checks have found some non-compliance. So it just shows you that it's a very small percentage, but also that 1/5 of all the checks has resulted in some type of non-compliance. So that's why it's important to have a cost-effective compliance, because you just avoid those risks. Now, this slide shows you all the different potential violations and enforcement tools that the U.S. government is using to make sure that each small business and each exporter is compliant. And essentially, they're divided in 4 different areas. There's criminal penalties for individuals and also potentially corporations. There's civil penalties, which could be seizure or forfeiture, also lawsuits, and just civil penalties. Administrative, such as debarment, and also contractual. So if the U.S. government seeks assistance on training in a foreign country and the individual is not obtaining the right permits, they could be terminated for default. Loss of export privileges, and also investigation. So if the U.S. government discovers non-compliance overseas, they might send a request to a business asking for additional information. Now, the export control reform has been helpful in a sense that it has consolidated all the different screening lists into one major website, and that's listed here under consolidated screening list. So if you're not sure if a foreign business is a good business to deal with, one check could be to go to this website and see if they're listed there or if any of their CEOs are listed. But essentially, any good export control policy starts with due diligence on your foreign partner. It's much easier to enter into an agreement with another business than get out of it. So before entering into one, it's very important to really identify any risks and benefits. Now we'll talk about cybersecurity and exports and what issues they pose for small businesses and exporters. So as you probably heard in the news, the U.S. government has been a victim of multiple cyber attacks. Apparently, there's hundreds every year. There could be one that is happening this week, but the Office of Personnel Management lost documents over 22 million people that have been affected by cyber attack. And they actually discovered that they were subject to an attack when they were upgrading their cybersecurity protections. And this attack was occurring for several months. IRS also has been affected by it. Multiple companies, a lot of companies, they don't even know that they've been attacked. Twitter was also attacked by of Associated Press, where someone reported that there were explosions in the White House in 2013, which just sent the stock market down. And also a lot of countries in Europe, such as Estonia or Ukraine, have also been attacked. And recently, there was a bank in Bangladesh that lost $81 million due to a cyber attack. So because a lot of export businesses that are small businesses that are exporters deal with controlled or technical data that is provided in support of the defense article, this data has been subject of cyber attacks as well. So it's very important to have policies, and the U.S. government expects that there will be policies that each contractor has that are internal policies to ensure compliance, or to at least ensure that there's adequate security, that no one can just log in the website and download all the controlled technical data for a particular product. Just to show how pervasive cyber attacks have been recently, a recent head of the National Security Administration commented that cyber attacks have resulted in the biggest transfer of wealth in the history of the world, because technical data can be very expensive, and once someone has it, they can just tremendously benefit from it if they know what to do with it. Now, in order to be compliant as an exporter or a small business with cybersecurity threats and requirements, it's first very important to identify what is cyberspace. And essentially, cyberspace is anything that you can connect to the internet. So your network, software, infrastructure, or anything else. There's many benefits with being connected to the internet, but there's also multiple risks. And in order to be a responsible contractor, the U.S. government expects all its exporters to be compliant and to have protections. Now, the Department of Defense has issued a new rule in December of 2015 that will take effect in 2017. But essentially, the first step is to really check what is in the contract. Does it address any of the export controls and export controlled information? And then how can I make sure I protect it on my shared drive or otherwise? By having a good cybersecurity policy and training for your employees, you can avoid any breaches and the mandatory reporting that comes with the breaches to the U.S. government, and also internal investigations that can be very expensive. And if there is a breach, you can quickly identify it and resolve it versus not knowing about it unless the contracting officer sends a letter saying that they suspect that some of the infrastructure has been compromised. This is the new rule proposed by the Department of Defense, which essentially states that by December 31st, 2017, contractors that have controlled defense information, which also is considered export-controlled information, must have adequate security measures in place. Now, it doesn't specifically state what measures have to be in place, but the National Institute of Science has developed what is called SB 800-53, which addresses some of those requirements. Now, anytime a contractor is subject to a cyber attack or they have a cyber incident, they have to report it within 72 hours. And contractors that are awarded a contract that has export control data in it that are not compliant have to tell the contracting officer. But by December 31st, 2017, everyone has to be compliant, or otherwise they will just not be awarded a contract. So it's very important to build those protections now, identify cyberspace, cyber risks, how you can protect not only export controls, but also export controlled information, but also any other proprietary or confidential information. Now, the International Traffic in Arms regulation has a specific duty to report if there's an export or otherwise. So if a company is being attacked and export controlled information is stolen, then this might trigger a reporting requirement because now this could be considered an export. And failure to report could be considered as a ground for an administrative action such as debarment or suspension. So that's why it's important to have this compliance aspect covered to avoid those issues later. Now we'll be getting into the reforms and opportunities for small businesses, and this is where the main focus for the next 10 minutes will be for our presentation. So essentially, now that we discussed the regulations, the potential violations and penalties, and also cybersecurity risks, we're going to jump into the export control reforms and opportunities. So in 2009, the U.S. government identified 4 main problems with the export controls, and you can see them on this slide. So first, there were outdated definitions, uneven penalties. In some instances, if you violated the United States munitions list requirements in the ITAR, you would have a lower penalty than if you had a comparable violation through the commerce control list. The U.S. government was trying to make sure that the same penalties apply for the same violations. Overlapping enforcement. So we saw this slide where there were multiple agencies involved. So now the U.S. government wants to make sure that there's no 3, 4, 5 investigations of the same violation by different agencies, and also overlapping jurisdictions. So one business could get in trouble with the Department of State, but all of a sudden now the Department of Justice and Department of Homeland Security or another agency would also try to get involved. And also, some investigations were compromised. So this is called blue on blue. So the Department of State would be conducting an investigation, but Department of Commerce wouldn't know about it, and they would take down someone, and then the Department of State didn't know how to deal with that. So this was supposed to be resolved by the export control reform, and right now, as it stands, the U.S. government is able to better coordinate all the investigations, and they primarily focus on a lower number of sensitive items that they seek to control. Now, the original goals of the export control reform was to have a single export control list, single licensing authority, single enforcement, and single IT infrastructure. Now, those goals were divided into 3 phases. So phase 1 and phase 2 have already been completed for the most part as of the end of 2015, and this was to update the definitions, review the United States munitions list categories, remove multiple items and transfer them to the commerce control list, so a lot of small businesses can start selling them internationally or otherwise. The Obama administration also established the Export Control and Coordination Center, which deconflicts a lot of those investigations, and there's been already a result where there's just less investigations, and because a lot of agencies can deconflict, and they've been reporting that there's just the number of investigations dropped by 50% because multiple agencies are just not investigating the same individuals. Right now we're in the last phase of the export control reform, which is to establish one agency that is responsible for export controls. And most experts agree that this will require an act of Congress. In the meantime, the U.S. government is trying to have this export control and coordination center, and also single IT infrastructure. So then if you have an issue, you can just go to one website and identify who's a blacklisted individual and who's not. And this creates a lot of opportunities because there's new items, new technologies, and new services that are available for exporting overseas. They are no longer restricted. They don't have accompanying regulatory requirements, and there's no fees. I think in one example that I've seen, a U.S. business wanted to sell something to a foreign company for $200, but they had to pay $250 for a processing fee to be allowed to do so. So the U.S. government is working hard to resolve issues like this. And this is probably the second most important slide in this presentation. This is essentially how the export control reform has been taking shape. So on this pyramid, you can see that there's three tiers. Tier 1 is all those technologies and all those articles that you want to be very familiar with because they're almost exclusive to the United States government. They're not for sale to anyone else, and this is essentially critical to national security to ensure that those items are only within the possession of the United States for the most part because this is critical for national security. Tier 2 is articles that are more available. They're available to a lot of allies and trusted partners for the United States. And if the United States has an agreement with the United Kingdom or Australia, then so long as you obtain proper permit, you can sell it. And finally, Tier 3, which is essentially all those new technologies, new articles that have been removed, and now they're just available internationally, but a lot of foreign businesses or foreign countries want to get products that are made in the United States because they know that the quality will be good. Now, on the left side, you can see the difference that the export control reform has made for the Department of State. So while in 2013, 87,000 individual applications have been submitted to sell something overseas, by 2015, this number has dropped to 47,000. And the Department of State expects that this number will be dropping. Major foreign military sales have been occurring to Saudi Arabia, Qatar, and South Korea, and there's a lot of demand there, not only from individual businesses but from countries because they want to have some of the latest technologies that are in Tier 3 or Tier 2 that are available through the U.S. government that have been recently removed. The United States is also a signatory to trade agreements, and it ratified the trade agreements with over 70 countries. So this means that foreign countries will have preferential treatment of their articles in the United States, but this also means that U.S. businesses that sell overseas will have preferential treatment for those articles overseas. So if there's a tariff that the country is applying to foreign goods because the small business can benefit from the free trade agreement between the United States and the foreign country, this tariff will most likely not be applied to the business that is selling in that country. Now, President Obama has also been recently traveling to Vietnam and Cuba, and there's an anticipation that a lot of export controls will also be removed from those countries. Now, another tier that is not visible here is Tier 4, which is all the excluded parties and excluded businesses and parts of the government. So essentially, you cannot sell to anyone that is excluded, regardless of what tier the product is from. So it's critical to always do due diligence and to double check that what you're selling is actually to the right person. Now, on the next slide, we can see some of the tangible benefits that the export control reform has created for U.S. businesses. So the U.S. government essentially analyzed who are major exporters in the United States, and they discovered that only 2% are large businesses. Everything else is a small business, and the small businesses have been historically the main engine of the U.S. economy. They have created most innovation, and some of those small businesses are the biggest companies in the world today. So the export control reform has really focused on empowering those small businesses to export more. And this has been created by reducing compliance costs, by clarifying definitions, improving its IT infrastructure, entering into strategic trade authorization agreements with a lot of countries. So a lot of those permits that take months are no longer necessary, and also consolidating exclusion lists. So a small business can just go to two websites versus spend a week trying to figure out if a particular business is good to sell or not. Now, the other benefits have been that there's been a lot of items transferred from the United States munitions list to the Commerce Control List. And the Department of Commerce, which manages the Commerce Control List, charges no fees for a lot of small businesses under certain circumstances. So this is additional benefit in addition to having those items that a lot of businesses want around the world, and not having to go through a long administrative process of obtaining a permit. Now the business doesn't have to pay any of the fees as well. In addition, the Small Business Administration established export assistance centers, and from what I've been hearing, they're very useful for a lot of small businesses to contact and to see how they can increase their sales. Recently, I attended a meeting by one of the representatives by the Small Business Administration, and he was essentially indicating that the Small Business Administration will work with the Department of State to meet with foreign businesses or foreign dignitaries to facilitate the transaction and do anything else that will help increase the sales. And we talked about the mass trade deficits that the U.S. has been experiencing. But now the U.S. government recognizes that by increasing exports, you can offset those trade deficits. And the U.S. government actually allotted a lot of loans and grants to small businesses that are seeking to export. Also, the Bureau of Industry and Security offers assistance to small businesses. So instead of going through an expensive process of retaining a consultant or an expert, those businesses can just call directly and try to speak with someone if they can resolve that issue. Now, if you go to the Small Business Administration Export Assistance Centers, you can find a link on how to actually apply for some of the loans and grants to facilitate exports. And you can see some of those websites at the end of the presentation. Now, most foreign countries and businesses want products made in the United States because they know that the quality will be good and they will reflect the latest technology. U.S. products can also be more competitive because of the pre-existing free trade agreements. And on top of that, the U.S. government has introduced the National Export Initiative, which essentially offers assistance to facilitate exports. And in the last several years, the number of U.S. exports have been dramatically increasing, and this is in part because a lot of small businesses are actually taking an advantage of some of the services that the National Export Initiative is offering. Congress also recognized this, so there's a new law or a new bill pending. It's called Boosting American Export Act, which has been introduced. So it's not a current law, but essentially instead of setting new embargoes or otherwise, the U.S. government is really focusing on how can we empower small businesses by loans, assistance, and grants to export more, and how can we remove more items so the businesses can really benefit from the technologies that have been developing. But even the best opportunity for an international sale must be compliant with the current laws. So right now we will talk about some of the cost-effective compliance mechanisms. Essentially, the U.S. government sees, and I recommend this too, to divide your compliance program into 9 different parts. Because essentially any new business opportunity is only as effective as your compliance program, because violations can be much more expensive than any business opportunity. And here, like we were discussing, how the Department of Justice is targeting senior corporate officers, it's very important to involve them from the start, because they will make sure the compliance program is effective. They will provide adequate resources, adequate training, and adequate responsibilities, and also they will award those who ensure that the program is compliant. Risk has to be assessed all the time. It's not only that you do due diligence at the initial meet and greet of a foreign business, but also right before the sale goes through, because you never know if that business was listed yesterday on one of the lists. Having written operational guidance is very important, because this allows those employees to follow it. And if they understand it and follow it, again, you avoid a lot of those risks. Laws are changing all the time. Export control reform is moving a lot of items from one list to another. You want to make sure you get the right items on the right list and obtain the right permit. So training is also very important. Compliance is from start to finish. So sometimes it's better to report something if you're not sure, versus just not reporting it, and later the U.S. government is coming back and saying, hey, we had a Blue Lantern visit and you didn't report something. Record keeping is critical, because if you don't have that permit that you were able to ship something, the government will assume that you didn't have that permit. So that's why it's very important. And also backup. Where's your export control information backed up if your system goes down, and how can you make sure that there's no cyber intrusions? A lot of businesses find it effective to have an export compliance reviews, either internally or externally. A lot of times, one of the good questions to ask is, who's checking that my compliance officer is compliant? Proper reporting of violations. That's probably where attorneys can be effective, because if something happens, it's very important to report it quickly, identify the problem, and also protect all communications under the attorney-client privilege. If this is reported by a compliance officer, courts have found that this will not be privileged. And taking immediate corrective action. If your corporate officer stays close and monitors the compliance and identifies an issue, he can quickly resolve it, versus waiting for a number of years, hundreds of items later, that something is reported, because this can have a very devastating effect on the company. Now, here are some of the potential red flags that a good compliance program should identify to really focus on the opportunities versus compliance issues. So where is the transaction going? Who is my business partner? Are they on any lists that they're not supposed to be? And what is the ultimate destination? Is it a country neighboring Iran, or is it Iran, or is it some other country? How can I make sure that if I disclose certain information to my business partner, I'm not making an export over the phone? How do I make sure that I and my business partner have all the documents? If there's some business that is evasive, or they want to buy everything in cash, or they don't really want to tell me where the item is going, or they're just ordering a lot, maybe I shouldn't go with this transaction. What is the individual really trying to buy? Have I recently heard of any cases that might indicate to me that this could be another red flag? And this is one recent example of a case study for compliance to Spain. Actually, this is very instructive in terms of first the amount. Someone wants to buy 2,000 night vision devices to Spain, and the end user for end use by the Spanish Marine Corps, which seems legitimate. Obviously, there's a lot of devices, but Spain is not a blacklisted country. The business partner is Alent SA, which is in Madrid, and then the U.S. business industries night vision exports 350 to start with as the first shipment, and then the U.S. Embassy in Madrid is conducting its visits to really see what is happening. And they quickly discover that not everything is going to the Spanish Marine Corps, because Spanish Army got some items, and also Spanish Intelligence Service, which like we were discussing, violates the terms of the permit or the license, because the license just says a specific number to a specific individual at a specific time. And also they re-export it to a private Swiss company. So the Department of State also discovered multiple record-keeping violations, and also that the company could not really account for 112 of the devices that they received. Meanwhile, the same company contacted another U.S. company called Envision Optics LLC to obtain DSP-05, which is an export permit, to export more night vision devices to Spain. By that time, the U.S. government was probably monitoring that, okay, there's a lot of night vision devices going to Spain. It's the same company. So they started to talk to the Spanish Ministry of Defense, and they discovered that some of the documents have been altered, and then the Spanish Ministry of Defense actually initiated an investigation. They also discovered that instead of 62, someone changed it to 462. Now, and a U.S. company probably at this time would not know that Elint was not a trustworthy business partner. But at that point, the Department of State issued a presumption of denial letter, essentially saying we will not deal with Elint. Elint is one of the companies that is not trustworthy that we can do business with. Elint didn't respond. We always recommend to respond. You either have a compliance program that needs improvement, or maybe someone is really intentionally engaging in the violations. But Elint, instead of responding, was retransferring more devices without any authorization to other companies. And then finally, the Spanish Ministry of Defense decided to initiate a search warrant of 2 employees. And because under the current laws, each violation amounts to 1 sale. So if you sell 1 item, that's 1 violation, and for 1 violation, the maximum penalty could be $500,000 at the discretion of the U.S. government. Because there were multiple transactions, the U.S. government accounted for over 300 individual violations. And obviously, the company was facing debarment, civil penalties, and otherwise. Shipping 200 or 2,000 night vision devices to Spain, when each device could be as low as $400 and as much as several thousand, could be very profitable, because that's a really large dollar number. But on the other hand, compliance is critical. Now, the U.S. companies did not get in trouble, but once Elint was listed, they could potentially face penalties by not doing due diligence. And these are some of the factors that the United States government is looking when it comes to deciding what's the penalty for non-compliance, and this is very useful for individuals who want to make sure that they're compliant. First, the U.S. government will look at what's the destination of the export. So if you check and it's not Russia, or it's not Iran, or it's not Cuba, instead it's going to a country in Europe or somewhere else, then that could be a mitigating factor because you did your due diligence there. Now, is there willfulness or is there an accident? Elint, it looks like they were intentionally violating the ITAR, but if there's an innocent mistake that has been quickly disclosed and resolved, the U.S. government most likely will give credit. Number of violations. If there's a poor compliance program, violations can last for years. And then criminal charges. Is the Department of Justice involved? Because this will affect how the Department of State or Department of Commerce is also involved. Mitigation. Voluntary disclosure is always welcome. Improving and enhancing the program is and compliance program is also important. And no previous violations. That's all mitigation. And obviously aggravation is high quantity, history of violations, and deliberate efforts to really benefit versus stay compliant. Here are some of the questions that should be asked or issues to be considered. When in doubt, it's always best to either speak with an experienced attorney or contact the Department of State or Department of Commerce response teams with questions, or request a commodity jurisdiction, because if something happens, you can always say, hey, I did the right thing. I requested commodity jurisdiction. I was giving it. The U.S. government provided it to me, and I was told that I was compliant. Voluntary disclosures are important, and they're actually expected. So if something happens, the U.S. government expects that it will be disclosed. Usually you have to have credible evidence, so this is not beyond reasonable doubt, but it has to be something more than hearing a rumor in a hallway that something was sent without proper documents. A lot of times this has to be internally investigated. A lot of businesses think that if the violation was just 1 or 2 or 3 items, then it doesn't have to be reported, but the ITAR doesn't have a de minimis rule. So long as there's one improper export, this has to be reported. If it's not reported, the fact that the company failed to report it could be held against the company. There's also internal compliance considerations. What is our record-keeping policy? How do we make sure that we have the designated compliance person? Who's the empowered official? Are we current with all the plans and laws? Do we have a hotline, or did we sign up for alerts? Department of State and Department of Commerce allow to sign up for any updates on training or otherwise, or new regulations, or you can just go to their website and see it there. So that's part of staying compliant and current with laws. Here are some of the most important links that you can use. The first one deals with the Department of State and the office that deals with the ITAR control. The second one is the Department of Commerce. Department of Commerce developed a special website for exporters to facilitate their decision-making and compliance. Small Business Administration offers a special website for export loans, which if qualified, offers a lot of opportunities for businesses. Then the Department of Treasury also offers some of the guidance on compliance with the Office of Foreign Asset Controls. And finally, the U.S. government actually created export.gov website, which offers a lot of opportunities. So you're encouraged to check all of them and then make sure you stay compliant. This concludes my presentation. Thank you for alerting me to the glitch that we were experiencing in the morning when we started this presentation. And if you have any general questions, please let me know right now. All right, I understand that there's one question that I was actually asked before, and this deals with if a contractor has a contract in Europe and they have to bring some export controlled information for an exercise, and the contracting officer says that they don't have to apply for any exports, whether that's true or whether they're shielded by the Department of Defense. And the answer is that they're not, because the Department of Defense has to make sure that all the contractors comply with the individual Department of State and Department of Commerce regulations. So if the contracting officer tells you that you can just disregard the ITAR or IR or OFAC, that's not true, and it's best to really check with those agencies first before shipping it overseas. This concludes my presentation. Thank you so much for joining us for the U.S. Export Controls and New Opportunities. If you have any questions, please feel free to contact me at the email address. And thank you so much for joining us for today's presentation.